And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. Hello, how's it going?
Could be better.
All right, so my understanding, you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance
Hey guys, and welcome to today's video. What starts out sounding like a routine court scheduling hearing quickly turns into a textbook example of how sovereign citizen ideology collapses in a real courtroom. The judge is calm, procedural, and focused on moving the case forward, while the defendant is already preparing to derail the process with identity arguments and pseudo-legal language. This case isn't about confusion, it's about resistance. Watch closely how the court gives chances, explains consequences, and still refuses to let nonsense override reality.
What did you want to place on the record?
well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for.
Right.
So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say
This is a critical moment many defendants underestimate. The judge isn't discouraging self-representation. She's warning him. Representing yourself isn't a shortcut to control. It's a risk that removes all safety nets. Courts are not classrooms, and judges are not coaches. Once trial begins, mistakes become permanent. The defendant verbally agrees, but comprehension is another story entirely. This exchange lays the groundwork for what follows, because the court is now on record that the risks were explained clearly and repeatedly.
Physiologists, I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to...
Here we go, the classic sovereign citizen pivot. Instead of answering a direct question, the defendant attempts to separate himself from his own name. Courts hear this argument constantly, and it never works. Legal responsibility does not disappear because someone rejects their legal identity. The judge responds strategically, refusing to debate philosophy and instead grounding the conversation in practical reality. Every clarification offered here weakens the defendant's position because it confirms jurisdiction while exposing the tactic for what it truly is.
All right. So let record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the
stop.
Yes, sorry.
All right. We're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right. So let the record reflect that Mr. Casanova has been given the copy of the indictment. And the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right. That is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. This being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction.
This exchange perfectly illustrates the danger of self-representation. The court provides the indictment, but refuses to explain it because that would be legal advice. The judge uses a vivid analogy to drive home the point. Choosing to act alone means accepting the consequences of that choice. The defendant's repeated claims of not understanding don't pause the process. They accelerate the court's intervention. At this stage, the issue is no longer curiosity. It's the defendant's inability to proceed competently.
Some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mm-hmm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mm-hmm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
District court, it's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
military
to counsel. I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed to sign counsel, period. That's it. So have a seat. Managed to sign counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right, so take a seat. Thank you.
This is where the court draws a firm line. When someone repeatedly claims they cannot understand basic procedure, the judge must act to protect the integrity of the case. Appointing counsel isn't punishment, it's damage control. The court is ensuring the record remains clean and that future proceedings aren't undermined by claims of unfairness. Notice how patience remains, but authority is unmistakable. The system adapts, but it does not surrender control.
All right, we're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. All right, so Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right. And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova, and after you receive all the discovery, then the next setting is going to be a plea deadline date.
These
The
jurisdiction
state will
questions
tender an
sound
offer to
impressive,
you at the
but
next
they are
setting,
legally meaningless.
and then I'll
Courts
give
do
you
not
your plea
operate
deadline
under
date,
imaginary
and you can
categories
accept
like
the state's
admiralty
offer,
or
come to an
military
agreement or not.
tribunals in
If
routine
you're
felony
unable to come
cases.
to an agreement
The
at that
judge
time, it'll
answers
be
once,
scheduled for jury trial.
clearly and
Thank you, Ms.
simply,
Boyd.
You're
then
welcome.
shuts the discussion
Any other
down.
questions?
This
I
is
have no
important.
further questions.
All
Judges
right,
are
so
not
Ms.
required to
Ferguson is going to
entertain
give me
repetitive
a
or
date,
irrelevant arguments.
and then
When a
you'll
defendant
sign it.
refuses
Mr.
to
Bonk will
accept
sign it
clear
to
answers,
signify
the court
when you're to
moves
come back.
forward anyway.
right.
Reality doesn't
I
bend
appreciate
just
your
because
time.
All
someone
right, you're
insists
welcome, and
it
thank you
should.
for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that,